Okay, when you were called up to Barry's office, you were given the right to be accompanied by a witness, is that correct?
I would disagree with that. I don't think I was actually given the opportunity to really...
But you were told before you went in that you could have a witness present with you?
I was told that I was allowed to have a witness, yes.
Okay, that's all that we needed. Is there any possible reason then why you declined to have a witness present with you?
Like I was about to say, because I really wasn't given the opportunity to respond, because before I had a chance, Barry had opened the door and I was invited in, and in addition to that, I wasn't really told what it was about. I mean, so, you know, to make a decision on whether or not I would need somebody, you need to understand what the reasons are that you're having a meeting, and that really wasn't clear.
So this is another submission, both the parties chance to sum up their case, to put across what they think that the panel, the decision of the panel should be. Thank you.
Madam Chair and panel, the claimants bring the following claims: that unfair dismissal is contrary to section 98(2)(b) of the Employment Rights Act 1996, and that there has been a breach of contract in regard to notice pay. The claimant was dismissed without notice for gross misconduct regarding to computer misuse. We feel that the respondents have failed to show the reason that Paul Smith was fairly dismissed. Therefore, they subsequently acted contrary to 98(3)(a) of the Employment Rights Act and contrary to the ACAS Code of Practice, in that no necessary investigations were carried out and no opportunity for the claimant to respond was given. We have to establish the test of reasonableness. This is established by VHS versus Birdshill. First of all, did the employer genuinely believe the employee to be guilty of misconduct? Was it a reasonable belief? And was it reached after reasonable investigation? The respondent's actions, we believe, are not fair. The disciplinary policy was not followed. It was not fair because the investigation was not carried out to a reasonable degree. The claimant was given no right to respond. The claimant's lack of objection has been used as a reason to continue with an unfair investigation. The evidence was not investigated robustly, and the client was not informed of his allegations in writing as per the testimony you heard from Rose, the HR manageress. The claimant was given no time to prepare his defence. Is there a reasonable belief of his guilt? No. There was no investigation undertaken to establish it. Reasonableness is defined as having sound judgment and having a fair and sensible belief based on good sense. We can see that this case hinges on the IT access, that the belief in his guilt was presumed on the fact that Paul must have used his computer because only he had access. But it's been proved without doubt that there have been at least 5 people, Carl, Rose, the administrator password, Dean, and possibly even the managing director, that had access to that password. Paul has 9 years of service, an impeccable record, and he said he didn't do it, which means that the managing director had every right to doubt that he was guilty. In the matter of the poll key, the client accepts that he did not sign out and acknowledges that this is a breach of health and safety and company policy. Underneath the company's own terms and conditions, failure to sign out would constitute a minor breach as an unauthorised absence from work. Rose, in her testimony, acknowledged that it is not failure to sign out is not gross misconduct, and that one instance would not equal gross misconduct under any normal investigation. Therefore, we find breach of contract was not gross misconduct in this case. The poll key reduction argument made by respondents therefore fails in our opinion. Thank you very much.
The claimant wishes to sum up as follows. The dismissal was for a potentially fair reason relating to the conduct of the employee, and the conduct was sufficiently serious to justify the dismissal of the claimant in the position that he held, which was relatively senior position in the company and one of trust. The employer carried out such investigation as was reasonable in the circumstances. The ACAS Code of Practice on Disciplinary and Grievance Procedures has a simple list of things to follow. Establish the facts of each case. We can see that the facts were established as the incident was occurred. Inform the employee of the problem. He was informed of such problem when he came back into the office. A meeting was then held with the employee, and he was allowed to be accompanied at that meeting, which he declined. As the claimant then decided on the appropriate action, and given the seriousness of the allegation, that action was carried out. And we then also provided the employee with a right to appeal, which he also did not do. At the time of the dismissal, we generally do believe that the claimant was guilty of the misconduct. The employer had carried out as much investigation as was reasonable in all the circumstances of the case. May I remind you that it is not relevant that the panel members may not have reached the same conclusions. The test is one of reasonableness, not the criminal test of beyond reasonable doubt. If the tribunal does not find that the dismissal was reasonable based on the above, which we believe it should do, we would like the tribunal to consider that the claimant contributed to his dismissal by breaching policies and procedures that other employees adhere to and reduce any award made accordingly. We also would like to just make a few things clear. Paul has proved to lie on several occasions. He also lied about his blog. This obviously proves that he doesn't think clearly when it comes to matters involved with Dean. He is also involved in the drafting of policy, so he is not unaware of things that happen within the company with regard to disciplinary procedures and policies. At the time, he was not thinking clearly, as he may have had the opportunity to come back into the office with those missing minutes and realize that he had been found out. This may have been one of the reasons. He left the office at 3 p.m. and the incident was recorded at 2:45. Again, we see Paul lying, as he has not had a repeat prescription and only one GP visit, and has not looked for work up until that point, so we feel that he is not entitled to the amount of compensation being sought. The claimant has alleged that an uplift should be made for failure to follow the ACAS Code of Practice, but we submit that this should be offset against the claimant's failure to appeal the dismissal. Finally, we have heard that the claimant breached other equally serious terms of internet use policy by his blogging and defamatory statements. This conduct had just been made known to a director of the company, and we believe that even if the claimant had not been dismissed for the conduct that led to his dismissal, he would have been dismissed for the blogging breaches within a short period of time, which we would say would be as short as 2 to 3 weeks to follow a procedurally fair dismissal. Thank you.
Party can be of any further assistance to you. If you'd like to take a break now and discuss with your panel members, and then let us know when you've reached a decision.
Thank you.
Thank you.
The fact he didn't sign out of the workplace hasn't done him any favours, and he wasn't following procedure himself, was he?
No.
However, seems like nobody else did either.
No, that's what I mean. It's also lax in the company anyway. So it's quite difficult.
Freak out in his own head, and then
And also
go
get
to a
advice
meeting,
from other
hasn't he?
people, because you can't, because in that stage of shock
gotta
and
think on his
you're
strength.
confused, you don't have a clarity of thought, and you almost need someone to do your thinking for you, or take you through what's going to happen next.
Are we
what's
getting
likely
close
happen,
to
that
a-
kind of thing.
Yeah,
Decision?
we all agree really as to what we think. Thank you very much for all waiting for us. We've deliberated for quite a while. We're still not sure on certain legal matters, but on the evidence that we've been given today, and in the light of everything that we've heard, in the balance of probability and the lack of company procedures and evidence to prove it was him, we actually find the company guilty of wrongful dismissal.
And your award, what would you be given?
In light of the fact that this gentleman has only been to his doctor's once and had one prescription, we think that he should have sought work, and therefore a large amount of compensation should not be awarded.
Okay. Well, thank you very much indeed. Okay. Well, those of you who know that there are a few more legal tests that have to be put down, but basically what the panel have done is they have decided on the facts as we have presented them. That's basically their job. Contributory negligence, etc., can all come into it. But at the end of the day, you've seen that the company lost. Whoops. When the chairperson is speaking and they're giving you the basics of where they're going, and you still don't know yet which way they're going to go, how many of you felt a bit anxious at that stage today? It's amazing, isn't it? Even today in a mock-up, I was like, and I didn't know, I'd been out talking to that, I didn't know which way they're going to go. If it were a real scenario, if you were really in the employment tribunal and really in front of you on the table was £24,000+, how bad would that feel? If you're HR, because that's the reality of it, isn't it? And it's lovely playing these games, and I've got to say that everybody did really so very well. I've seen trainee advocates, qualified solicitors that can't do what you have done. They can't get it together, and that's why they go on to do these training. So you have just done really so very well, fantastically. We've lost, the company's lost. So now all of a sudden we're going to have to pay 20-some odd £1,000 in damages. What about the costs? Does anybody have any idea of how much this would cost for a company to get this far? You're talking about in the region of a case like this would easily cost you 10,000+ in legal costs. It's amazing. So when you add on the awards that are going to go against you, the loss of management, which is the main biter in this, because this trial, this hearing today, has taken all of the management of this small business, all of them, over to Birmingham, into the tribunal, the travel, the anxiety, the disturbance, talking about it before and after. It really is something that you need to consider in your small businesses when you are looking at what might come in the tribunal. So even if the company would have won today, they would still have got the legal expense that they'd have to have covered, and I'm just going to talk about that in 1 second, but they would have had the disruption to the business, which is massive. It's like a nuclear explosion right in the core of any little business, because people, instead of talking about what they should be doing, are talking about what XYZ is saying, and the investigation, it's disruptive, and you'll find that a lot more problems come from it than just the main problem that you're investigating. It's got a knock-on effect, and it opens up cracks. And virtually every single case that we're involved in now has got a costs consequence to it. And the majority of those costs, those consequences, have come when a claimant brings their own claim, because they're saying and doing things that actually are deemed to be very unfair in the litigation against the company. But nevertheless, even with advocates, so even if you're a HR company that looks after other companies, as far as employment and hearings are concerned, there is the opportunity now available to sue. So the successful party in the court can sue the solicitor or the HR or whoever it is that is looking after the claimant or the respondent for the other side. So you get a two-way costs argument going, and they're very real, and they're getting more and more often, and they're getting more and more successful. And so we talked about the costs of the main argument. What are the costs of two lawyers battling in court over a cost, a 10 or a 15 or a £20,000 legal costs? Let me tell you, they're 20,000 plus. Any kind of a case like this, where you're coming along with a basic payment at the end of it of your 20, you can add easily, if it goes badly for you, which it can, you can add another 20 to that very, very quickly. So you've got to be very, very careful right at the roots to be dealing with this properly. And you've seen in evidence today that actually people say things and they get carried away in the moment with it all, and it's all very, they want to get their case over properly, and things get said that aren't meant. And you get a clever advocate on one side, and he can be led to say things that you don't mean. So you've got to be very careful and get it right very, very, very early on. And I hope you all enjoyed today. I certainly did. Thank you very much.